We all know that family law cases can be complicated, which is why you and your client deserve reliable, hassle-free drug and alcohol testing services. From hair testing to abstinence monitoring, we can help. Visit lextalks.co.uk for more information.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we are talking about pets. It's been brought to the attention of Today's Family Lawyer, and indeed we've published a story about a recent petition that has landed in Parliament to distinguish pets from other types of property in civil and family proceedings. And while I don't have the authors of this petition on the discussion today, I actually have perhaps one better, a new working group, or a relatively new working group that's been set up to look at this subject. And from the working group, I have co-founder Sarah Lucy Cooper, a barrister at Thomas More Chambers, Diane Matthews, a senior associate at MSB Solicitors in Liverpool, and Karis Nafte, a certified dog behaviour consultant and an accredited family mediator, and you act in pet custody mediation cases as well, Karis. Really interesting topic. In the first instance, I wonder if you might give me a little bit of an insight into what you do and your roles as well in this campaign.
Hello, I'm Sarah Lucy Cooper. I am a family law barrister at Thomas More Chambers, specialising in international cases, in particular those in Spain and Latin America. I also sit part-time as a family recorder, and I am a mediator and an arbitrator. Possibly most relevantly for what we're talking about today, I'm a dog owner, and I do like my dog. And really, I came to found this working group jointly with Estella Newbold-Brown because, as my parents always said to me, if you want something doing, do it yourself. No one else was doing anything on this topic, so I decided really that the time was right for something to change, particularly because I had relatively recently been involved, together with one of the other members of the working group, in an extremely acrimonious financial remedy case in which one of the many issues in dispute was the ownership of the dog, a dog that had been clearly paid for by the husband, but the husband, being in prison currently, was unable to care for, although he was seeking it within those financial remedy proceedings. And possibly that case crystallised for me the real problem that the law of England and Wales has in relation to the treatment of pets.
Karis.
Thanks, David. So my role in general is that I work in pet custody, whether in the role of a mediator or in some instances as a consultant if mediation is not an option. But my background before I started doing pet custody work is about 25 years working as a dog behavior consultant. In that role, my job is to work with families whose dogs are having behavioral problems of some sort, whether it's anxiety, or dogs who are aggressive, or dogs who won't stop peeing in the living room, dogs who've bitten children, everything you can imagine, all sorts of dog breeds. And I have worked over the years with so many dogs who, after a divorce, were not coping with a custody decision. So whether it was maybe the person with the better lawyer ended up with the dog, let's say, who didn't really want the dog, or a dog was in a shared custody situation that the dog was not coping with, because not all dogs can cope, shuffling back and forth between homes. And working with those families, kind of from the other side of it, trying to sort of repair a situation that was not good for the dog or the cat, I decided to shift the work I do to actually focus on how to help people make the right decision for their animal. So sort of prioritize the animal in the divorce, with all the emotions that are flying around, with all of the layers of divorce that happen. Can we make a decision that is the right one for the dogs? And from there, my work has really grown into providing training for divorce professionals in the voice of the pet and the best practices for pets and in divorce, whether it's mediators or divorce lawyers. I've published a book on this subject, and it was through all of that work that I got invited to be part of this fantastic group that is doing such important work to change the way animals are treated in England and Wales in divorce. And I'm really excited to be part of the group because my role in this group is to provide sort of the animal's perspective on things, whether we're going to share the dogs or not, what criteria should be looked at in determining what home the dog ends up in. Broadly speaking, I'm here to sort of voice for the dogs, voice for the cats, and work with this wonderful group to get some change going. So I'm really happy to be here.
Thanks, Karis. And to you, Diane, please.
Really must echo Karis' sentiment here. I am delighted to be a member of the working group on pets and divorce and separation, where the firm of solicitors involved in the recent case. It happened in December 2024, when the judgment was handed down. Interestingly and quirkily named by the judge 5E Doe. And this has actually been quite groundbreaking. I know the judge, she's a fantastic judge. I've appeared before her many, many times. Very sensible and very pragmatic. But to understand how interesting this judgment is, you have to understand the current position in law. And considering that we are much reported as being a nation of animal lovers, our treatment in divorce of the family pet really needs to improve. Essentially, I've spent more than 20 years practicing family law. I've explained to many, many people who've been quite incredulous that, well, your pet is a chattel. And that basically means they have the same status as your sofa or your television, which is incredible. I have to tell people, well, yes, your dog is a depreciating asset. And what we're going to do is look at things like who purchased the dog or the cat or the horse, whose name they could be registered in, whose name's on the chip, all that kind of thing. And that's what the law says. They are chattels. It's a different position overseas. Lots of different countries have changed their process. Some have changed by legislating. Others have changed through the development of case law. So, there are settled ways of dealing with this if we look outside our own country.
So the light has been shone on this particular issue. But Karis, how is this manifesting during proceedings? What's the problem here as far as separating couples are concerned?
So part of the problem would be, let's say, for example, there was a couple and they had, we'll call it Rover. And let's say that the woman in the relationship purchased Rover and, her name is on the certificate. But during the course of their relationship, it was the husband who was the one who took Rover to the park every day and took Rover to training classes and really took over the ownership and the main relating to the dog. And the dog was clearly bonded to the husband in this picture. And then let's fast forward and say the relationship has gone south for whatever reason. And maybe the woman in my example, is very angry about the fact that the relationship is over. And she could argue that, nope, the dog is hers because her name is on the paper and she paid for it. And the law is not.
This audio was created with Podcastle.ai.
Her name is on the paper and she paid for it. And the law is not technically allowed to account for the fact that the husband was the one the dog is bonded to. That's sort of what I look at in my work. It's like, who is the dog actually connected to? Who is the most ideal owner of the two people for the dog? And in this example, the woman could probably successfully argue that the dog is hers. She could take the dog. And that's really tragic for both the dog and him in this example. So that's how it manifests. We can't look at who's going to have the best long-term situation for the dog. We're not even really allowed to look at the dog's sense of happiness or the dog's sense of well-being or the cat's sense of happiness or well-being. Sometimes there's families where there's 2 or 3 dogs, and the dogs could be very, very bonded to each other, but one person can prove ownership of one dog and not the other, and so the dogs might have to be separated, which is not fair on those dogs if they're a strongly bonded pair. So those are just some examples of the way things can go wrong. There's whole other conversations about domestic violence and how that all comes into it. I don't even know if we want to touch on that subject, but that's a huge layer to these things. So those are some of the problems. We're not allowed to think about, hang on, what is the right situation for the dog? We can't look at this from the pet's perspective. We can only look at it from the perspective of who owns it, who paid for it, and that's it.
I also think it's really important to remember, if you're dealing with a financial remedy case, it's like strands on a rope, if you will. There's so many that make up the case, and sometimes you will find if you crack one item that means a lot to the parties they're emotionally invested in, it's incredible how much will then follow, a bit like the domino effect. And I think that's really important. There was one case I was involved in a couple of years ago which settled without proceedings, but I didn't think it would. I thought we were going to end up in court, and it was getting quite entrenched. But we had 3 ponies and 3 dogs. Now, the ponies were ridden by the children of the family. The husband had basically paid for them, but he couldn't ride. He probably wouldn't know how to, well, there's no probably in it. He wouldn't know how to care for the animal. The children rode the horses, and they rode them at quite a high level. But he could prove, I've paid for them, they're family assets, the chattels. And it looked like we were going to have a very, very bitter dispute on this. And finally, in somewhat more hope than expectation, I wrote quite a lengthy letter to his solicitor and said, well, look, we accept these animals are chattels. I was more concerned with the horses at this point than the dogs. Managed to get the dogs to follow fairly rapidly. The reality is the children would be devastated. The impact that's going to have on the children, we cannot overlook. Your client has got no hope of looking after these animals. He doesn't know what to do. He doesn't have time. He's never cared for them. And ultimately, that man saw sense. Okay, don't get me wrong. We had a few spirited arguments, but it made the rest of the case so much more straightforward because we've been able to box off something which looked like it was going to be a big argument. Now, I don't know what a judge would have done in that situation. I suspect they would have been regarded purely as chattels and would have been, I almost said horse trading, but that's a little bit much of a pun, I think, totally unintended. And, if we then look at 5E Doe, my colleague Susie Parker was involved in that case. She worked incredibly hard alongside her barrister, George Patterson. The judge made, I think, a really brave decision, because don't forget, we've not had any change in legislation or case law, but this judge looked at who the dog considered to be her carer. It was a dog where the parties could prove that they had both contributed to the purchase. The dog was a chattel. The dog was an asset of the family. I won't go into the details, but there've been a few unpleasant episodes where a husband had tried to snatch the dog, and it was not pleasant at all for anyone. But the judge made the right decision, I think, looking at who this dog thinks that you are my carer. Where did the dog consider her home was, and the children, and the relationship of the children and the dog. And we all know how special a bond that is. But I do still think that was a brave judge. But that is now the leading case. I'm hoping that, that's going to pave the way to some very sensible and very pragmatic decisions going forward.
What I sense at the moment then, in terms of the position in law, is that we're really appealing to, I don't know, a sense of morality, a sense of right and wrong, rather than being able to hang our hat on anything legal. But there are other jurisdictions, Sarah, that have tackled this issue quite recently, aren't there?
Well, that's absolutely right. And as I've indicated in my introduction about me, I do a lot of work with Spain and Latin America. And it may come as a surprise to some of your listeners that Spain, for instance, legislated about this very issue around 3 to 4 years ago. There are many jurisdictions also in Latin America who are far more advanced than we are in relation to the treatment of pets on divorce, including Argentina and Colombia, where they have the concept of a multi-species family, no less. One of the things that we have achieved in this working group is we have put together a whole analysis of 14 other jurisdictions and the changes that are going on in those jurisdictions in relation to the treatment of pets on divorce. Some of those are common law jurisdictions, such as Australia, Canada, the USA, New Zealand. Some of them are civil law jurisdictions, such as France, Portugal, Italy, Romania, Germany. So we are now at a point where we are lagging behind, having considered those other jurisdictions, particularly the common law ones, where it might be said that their existing divorce legislation probably fits more neatly into the sort of model that we have in England and Wales. What we are suggesting is that the Australian legislation, which is just about to come into force, they've already legislated for it, and it comes into force on the 10th of June of this year, but in fact was very largely based on the Canadian model from British Columbia, that in fact we opt for that. And what it does is it sets out 8 criteria, all of which are very sensible and the sort of things that us as lawyers could come up with if we were asked to, as to deciding where a companion animal should live if there is a dispute on divorce. And the factors include issues such as who has been paying for the animal's ongoing costs, who has been doing the ongoing maintenance and care of the animal, the relationship of the animal to the various human beings in the case, and also issues in relation to the ability of a party to care for the animal in the future, and whether or not there has been either any domestic violence against any of the human beings or against the animal itself. So it seems to us a very practical list of criteria, which of course has actually been tested in practice, albeit in British Columbia in Canada, where it's already been enforced for coming up to 2 years. And anecdotally, we are told it has been a huge success in Canada and has actually decreased the amount of litigation because more parties who are in dispute are able, therefore, to go to mediation, understanding clearly what criteria the court would apply should they litigate.
Why is this something we need to be thinking about, Karis, specifically in terms of animal welfare, I guess?
For a country that loves dogs as much as England does, as much as the whole world does, the specific category of divorce seems to lose the dog in the discussion, or lose the cat. It's like suddenly we're not able to have the discussion about, well, hang on, what's actually right for this dog? And if you think of how much we care about our animals in so many other circles of life, and we're hugely concerned with their well-being and their, is the dog anxious? Are they okay? Are they happy? Are they living their best life? To not be able to ask those questions in relation to divorce means we're losing touch with how much we care for these animals in a family setting. We have to be able to ask that question even when people are emotional. And I think that's a big thing that people need to be cognizant of who are working around divorce, is that the animals can hold so much emotion for people. They can represent so much to people. It can be the ultimate sense of failure to lose the dog. It can be the ultimate way to hurt your ex to manage to keep the dog or keep the cat when you know they love it so much. I mean, what a great way to hurt your ex, to take their beloved dog from them. I mean, and the fact is that the way legislation is written now, it leads it open to do that. I mean, one of my saddest clients I had was a woman who called. She'd had 2 little small dogs. Her boyfriend's mother was a dog breeder and had given them these 2 puppies over the course of their 4-year relationship. And she'd raised these dogs. She had Instagram accounts for the dogs. They were her whole life, absolutely loved them. But when they broke up, one day when she was at work, her ex just took the dog back to his mom's house. How's that for an analogy, guys? Took the dogs back to his mom And she wasn't allowed to, she had no foot to stand on because she had not paid for them. And the registration had never been put into anyone's name but the mom. And the mom just said, nope, I never gave them. They were my dog. My son was looking after them for me. And if the laws had been different for her, she could have proven that she was the one that was bonded with those dogs. And I would love people to listen to imagine, how would that feel if that was you? How would you feel if your beloved dog was scooped out from under you for yourself, but for your dog also? Or your cat, or your hedgehog, or your pot-bellied pig. If we love dogs, we love them, no matter what the circumstances. We can't exclude divorce from that.
Completely agree with that. I think that was a very eloquent explanation. I mean, no one is going to say for a moment that the position of the dog is sort of going to trump the position of a child. It would be foolish to do that. But there's a lot of noise around things like, well, you know, we've got lots of delays in the court, and we've got massive delays. My trainee issued an application last week looking to do 2 applications without notice, a domestic violence injunction and a prohibited steps order to prevent.
Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
This audio was created with podcastle.ai.
A domestic violence injunction and a prohibited steps order to prevent this, basically someone removing a child. We are still waiting for the court to make a decision on whether that's going to be done without notice or not. So the courts are clogged up. But this isn't going to make it worse. The situation, anecdotally, from other jurisdictions suggests it will improve the delays within the court systems. You cannot divorce the situation from reality. Most families, when they have a family pet, the children are very, very, very fond of the animal. And most times it's the child who will be very hurt. And I think it's quite wrong to overlook that point. We've got to look at the big picture. We've got to look at the family dynamic. Yes, there are certain cases where, you know, there won't be a child and one party may well be closer to the dog than the other. But surely in the 21st century, we can do better than think pets are chattels and no more worthy of consideration than the pots and pans you've got in the cupboard.
I guess the thing that's in the back of my head around some of this, and as the author of publications that tackle legal news on a daily basis, why, Sarah, is this issue important against the backdrop of all the challenges that we have in law? And I'm in family alone, I'm thinking about cohabitation, financial remedy, surrogacy. This is really quite a minor issue, surely.
I think it's an absolutely fair question, and there are maybe many people out there who are not animal lovers who think, well, you know, why isn't this working group devoting themselves to some other topic? The reality is that there is a lot of work being done in relation to reforms in respect of cohabitation, domestic abuse, all sorts of other issues. But this is a real issue, and it's not a niche issue. There are around 30 million dogs kept as pets and a similar number of cats kept as pets in the UK. That is an awful lot of divorcing couples who will have a pet. This is not a new issue. In fact, my attention was alerted to a case before Lord Denning in 1968 involving exactly the same issues, and it's an extremely amusing read in which counsel for the husband was Alan Ward, later to become Lord Justice Ward, and who I have spoken to about his appearance in the case. The other really key issue is that, frankly, the UK now is lagging behind other jurisdictions. They have overtaken us in just making small changes to their legislation to ensure, which is all we're asking, that pets are not treated in exactly the same way as any other chattel. I think really given all of the changes that there have been around animal protection and animal welfare in general, we all know, whether we like companion animals or we don't, we do know that in some sense they have a welfare need that needs to be protected, which may well not be protected merely by ownership just being conferred on whoever actually wrote the cheque in the first place.
Obviously, there's an awful lot out there that needs looking at. I mean, cohabitation law is an absolutely massive one that I come across on a daily basis. The point I would make, which is just more or less agreeing with Sarah Lucy, is these are massive issues which are going to take a lot of thought, a lot of work, a lot of drawing attention to resolve. The problem that we have involving pets and in the law is actually quite easy to remedy. We've got blueprints from other parts of the world. We don't have to spend hours and hours and hours writing, proposals and plans and legislation. We can basically piggyback on other people's hard work. Whilst there are other massive areas around which do require lots of attention, this is, I would suggest, given its impact on other areas of family law, something that we can resolve quite quickly, and it shouldn't detract from other things. And who knows, perhaps the working party could then find another worthy cause to think about.
And what I would add to that is, I think we can't underestimate the fact that if these changes are made, it will unclog the system, because then people will work it. Then there is a discussion to be had. It's not just we're going to add this to the longer fight and draw it out. People will be forced to choose other avenues to work through it in a more sensible way. It will reduce the weaponizing of the animal. I mean, if you talk to divorce lawyers where the pet has been a major issue, it can be a huge issue and clog everything up, and it gets rid of that. So it's time saving. It makes this easier for everybody, and it really helps the animal and it helps the people too.
I'm at the coal face every day that I'm in the office. I have to deal with the clogged up court system. I have to tell people, hey, you know what? Yeah, your child, I completely understand your child's at risk of being snatched by the other parent, but it's 72 hours before the court is even going to look at it. So you know what? Get on with it. That's not good enough. The system is broken, and this is a way to perhaps help a little bit of it recover.
This is another example of legislation simply not keeping up with societal changes. But you're not asking, Sarah, for major reform and changes. You've got a survey coming out in the next couple of weeks, which you're very welcome to plug. And you have a blueprint from Australia that we could implement reasonably quickly.
That's exactly right, David. We will be having a survey, Resolution, the Family Law Bar Association, and also the Scottish Family Law Association have all agreed to run that survey. So to all of the members of any of those three organisations, please make sure you fill it in within the next couple of weeks. We don't believe that this is some sort of niche issue. Both myself and Diane are ladies of a certain age who have worked in family law for many, many decades between us. These are cases we do see day in, day out. And we very much suspect that the rest of the family law community has also seen them. What we are seeking is for a relatively simple change, as Diane has well put it, piggybacking on the back of somebody else's legislation. It's sensible, it's easy, and it's tested in Canada. So let's just get it done.
I have absolutely no doubt that there will be lots of practitioners listening into this, rolling their eyes, no doubt, at the challenges that they've faced historically with pets. And who knows, perhaps this is a relatively simple way of resolving it. But at the very least, we have brought this to people's attention. I myself wasn't particularly aware of this as a campaign until very recently. So hopefully we've been able to do the same through the podcast. Thank you so much to Sarah Lucy Cooper, to Diane Matthews, and to Karis Nafte for joining the podcast.
Thank you for having us.
Yeah, thanks for having us.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to our guests. Thank you as ever for listening. and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
This audio was created with Podcastle.ai